Yes, Judge. No joke.
Good morning, Mr. Child. So you're charged with assault of a family member. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Your Honor. Law enforcement officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber.
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor. It's
And
reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Actually, stay close to that area. We don't come here. Stay close to that area.
Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over and called the security officer on duty. But the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. Once the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they were trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said if they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's what we're at.
Do they see any visible injuries, anything of this nature?
No, Judge, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically, that the punch was of such force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. I think that's where we're at with that.
Again, just to answer your question, there's no indication that there were any injuries at all, any marks. And as he just read, she said she did not feel pain. She did not want to press charges. And I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch to?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see
And
anything?
I don't see any indication that they saw anything.
And she says, I don't know. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in hell. Really. We have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
Good morning, Ms. McKnight. Ma'am, you're charged with two cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine. First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
She been given conditions not to go back.
Let me check her.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm praying about that person.
I don't want you to have contact with this person. Do you understand? Or you understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides to the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about do I have to come to court so I get in contact with him because we have a child.
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well.
Yes, sir.
You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint your lawyer today. I'm going to have you sign a reset with Victoria and then we'll have you take a seat in the jury box while I find your lawyer. Don't leave until you sign our bond conditions.
Your Honor, I want to wait for the lawyer check to set bond on the new case as well.
Yeah, I guess so.
All right, Judge, next is,
Judge, I guess, Judge, no, Judge, if I
Speak English, sir.
Judge,
You like a translator or do you speak well enough?
no, sir.
All right, Mr. Octaviano, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendant had trouble maintaining his balance, slurred speech, and drowsy eyes. Defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from. Standard field sobriety tests were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Who said anything about driving? Did anyone?
So,
I know you have the admission, but
right, and they said there was several witnesses that saw him. I'm checking now to get some details on an actual accident, Your Honor.
you have witnesses that put him driving.
Yes, Your Honor.
Okay.
There was officers there that saw him.
I don't know if those witnesses are named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing, you know, if it goes, right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas
He does,
license?
Judge.
You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So,
Yeah.
Right this way, go ahead, I'm sorry.